Thanks, Bishop, and hello to everyone. I'm very happy to be with you today. In preparing my comments, I really struggled to try to anticipate what aspects of the bankruptcy process, particularly as applied to Catholic organizations, dioceses, of religious orders, what would be the most interesting aspects of that process to the people attending this group. And I hope that I'll be able to touch on some of the things that are interesting to you. And if I've missed something, I'm welcoming your questions at the end of our session. And if there's something that you'd like to follow up on, please don't hesitate to contact me. I became interested in the sort of legal aspects, fascinating legal issues in Catholic bankruptcy cases a few years ago, in part because I'm a bankruptcy lawyer and a professor of bankruptcy law and other commercial law topics, but also because I'm a lifelong Catholic and am interested in the impact of this sort of unprecedented legal event in an institution that I care an awful lot about. And that's really the kind of genesis of my interest in the topic. What I thought I'd do today is talk about, explain some very basic ideas that are absolutely fundamental to kind of having a way of thinking or a frame of thinking about what a bankruptcy case might mean for a Catholic organization. First, let's start with a kind of a flyover, quick flyover of what happens in a bankruptcy case. And before we do that, I just wanted to explain that when I refer to bankruptcy, or when you hear about a diocese filing for protection, a bankruptcy case, it's seeking recourse to federal law. Title 11 of the U.S. Code provides, it's a very long code, super long, provides for relief for debtors, both substantive law and an elaborate procedure whereby debtors can apply for relief in a federal bankruptcy court. And the process, of course, is federal, but what happens in a bankruptcy case depends on state law, a lot of state law relationships, debtor-creditor relationships, the claims, the legal basis of claims, for example, of sexual abuse claimants, they're all creatures of state law. And federal bankruptcy law respects those state law entitlements to an extent. Like any federal regime that coexists with state law, where bankruptcy law conflicts with state law, bankruptcy law is going to preempt state laws. That's because under the US Constitution, Congress reserved the power to make bankruptcy laws in Article 1 of our Constitution. So it's a federal state symphony, but bankruptcy law is going to preempt state law whenever they're in conflict. Important to remember that when an organization, a debtor, files for relief in bankruptcy, the world divides into two time periods: the pre-petition period and the post-petition period. So the filing of the petition marks the end of era number one and the beginning of era number two. And of course, that divide, that chasm, that demarcation in time becomes very familiar and comforting or comfortable to bankruptcy lawyers, but it can be odd to people who are thinking about a bankruptcy procedure who don't think about it all the time. Events that occurred, relationships that arose, liabilities that arose in the pre-petition period are going to be treated in one way, and those relationships, events, and liabilities that occur in the post-petition period are going to be treated under bankruptcy law in a different way. On the petition date, two very important things, legally important things happen. First is an injunction, a kind of universal and automatic stay or injunction of all litigation against the debtor. And we talk about a petition for relief in bankruptcy. That's mainly the relief that the debtor gets on the moment that their petition is stamped in the bankruptcy courthouse. Without any further process, all litigation in state courts and federal courts, any kind of collection activity against the debtor is enjoined. And that can be a tremendous advantage in just obtaining a little bit of breathing space to conduct the negotiations that are to follow in the context of a bankruptcy case. The second thing that happens on the petition date is the creation of a pool of assets. This is a sort of, I suppose, a legal construct, but a pool of assets that's referred to under bankruptcy law as the estate, the creation of an estate. And on the petition date, the debtor becomes a kind of custodian for the estate, and the estate is, at least as the metaphor goes, the source or available to pay the claims of pre-petition creditors. So you have this injunction that protects the estate while the bankruptcy case is pending. Another basic concept involves terminology. The word bankruptcy has a lot of connotations. People associate it with, the cartoon character wearing the barrel with his pockets turned out, kind of an assetless state of affairs, utterly bereft and insolvent. Debtor doesn't have to be insolvent to file for bankruptcy. Indeed, the Catholic organizations that have filed for bankruptcy may or may not have been insolvent, but it's really not important for purposes of access to relief. There are two pathways. Once you file for bankruptcy, there's two pathways to solve your debt problem. And the first one is liquidation. And the second one is reorganization. Liquidation is, of course, an attractive option, but not for Catholic organizations that, for canonical reasons, simply cannot liquidate. But when I say liquidation, what I mean is that the estate that's metaphorically created upon the petition date is collected and sold, with the assets generated by the sale of the estate used to pay down creditors' claims, pay off creditors' claims. So the estate, the value of the property, provides the solution to the debt problem. That's pathway number one. Pathway number two is reorganization, a case under Chapter 11 of Title 11 of the U.S. Code. And in that pathway, the solution to debt problem is typically not liquidation, but rather a negotiated, multi-party negotiated solution where creditors and other parties all agree on what's known as a plan of reorganization, where creditors will have their claims paid out of the kind of going concern operational value of the debtor, but subject to the same types of protections that they'd be entitled to if that estate were hypothetically to be liquidated. So although Chapter 11 is its own pathway, creditors are built into Title 11 entitled to a kind of baseline treatment that reflects how they would have been treated if this particular estate was hypothetically going to be liquidated in a Chapter 7 case. All right, so what's it like to be in a bankruptcy case? I think there are people who are participating today who can answer that, not as I do as a scholar, but because they've got the lived experience. But a couple of key points that I'll make about that: why life as a debtor in bankruptcy is different than life not as a debtor in bankruptcy. First has to do with information and disclosure. Once you seek relief in a bankruptcy case, you become obligated to provide a huge amount of information for the benefit of your creditors about your financial operations. You need to provide lists of your creditors. You need to provide information about how your property is titled, who else might have claims and interests in your property. You need to make disclosure about your cash management systems, your insurance environment. Huge amounts of information that's otherwise private and proprietary now becomes subject to compelled disclosure. So that's number one, and that's a big one. Number two, when in thinking about claims, let's talk about sex abuse claims. Outside of bankruptcy, each individual claimant is kind of like a lone ranger, a cowboy pursuing his own agenda. Once the debtor files for bankruptcy, claims are treated in a more collective fashion. And bankruptcy imposes a sharing norm on all creditors who are similarly situated, are treated as claimants in the same class. And in a Chapter 11 bankruptcy case, sex abuse claimants typically are organized into an official committee where instead of kind of each speaking with their own voice, the committee speaks collectively for the benefit of all of those similarly situated claimants. So you move from an individualized norm to a collective norm. And I think that's an important distinction to note. Once you're a debtor in bankruptcy, professional fees, the costs associated with your own representation in the bankruptcy case, and in the costs incurred by other parties and interests, for example, the official committee of sex abuse claimants. All of those professional fee relationships are subject to disclosure and the supervision of the bankruptcy court. It's a way of bankruptcy provides a way of managing professional fees, which can which can be overwhelming outside of bankruptcy. It certainly doesn't eliminate those fees, but it just provides a court supervised process in which those fees are subject to scrutiny and management. Last thing I wanted to mention is the claims process. What happens to sex abuse claims in a diocesan bankruptcy case? Well, I mentioned that abuse claimants are treated in a collective way. They're typically represented by a single committee. In a bankruptcy case, the claims are going to be administered in a way that maybe a crude way of describing it is they're batch processed as opposed to individually litigated, or at least pursued in an individual way outside of bankruptcy. So all claimants are asked to complete a proof of claim form, which doesn't require a lawyer to complete. Asks for some simple information about the nature of their claim and some of the facts on which they rely. The bankruptcy court will impose what's known as a bar date, meaning all claims against this particular debtor have to be submitted via a proof of claim form before the bar date, or forever hold your peace. The bar date means that claims that existed in that pre-petition period but didn't get asserted, it's just going to be too late for those. And that, of course, applies and is effective. The bar date is effective, even if the state subsequently enacts revival legislation, for example. That's state law, and the effect of the bar date is federal law. And as I mentioned earlier, applying that conflict supremacy, federal law is going to trump even claims revival legislation. Just a fact on this, looking at cases since 2017, about 11 Catholic diocesan cases since 2017, the bar dates have ranged from between 54 to 191 days following the petition date, which gives you a kind of a rough idea of how long that claims accumulation process lasts in a bankruptcy case. Once all the proof of claim forms are in, as part of the terms of the plan of reorganization, negotiated plan of reorganization, one of the negotiated terms of that will be a claims administration protocol. Typically, the plans have provided for the appointment of a, names vary, but an abuse claims administrator, an independent evaluator of the information provided on proof of claims forms, who determines how much each particular claimant is going to be entitled to receive from the fund established by the plan of reorganization. And the plans so far have used an evaluation system, which I find to be quite interesting as a lawyer, because it really has very little, sort of loosely connected with the way those claims would be litigated outside of a bankruptcy case. There's the points factor, there's plus points based on the nature of the abuse, the type of abuser, the impact of the abuse on the person, and minus points. If the abuser was, for example, not a diocesan priest, you lose points that way. And then at the end of the game, once the size of the pot is established, all of those claimants will receive a check based on the kind of par value of the number of points that they have relative to the size of the pie. It's a very pragmatic way of administering claims, in contrast to the usual kind of litigated court proceedings subject to the rules of evidence, which kind of yield a very different result. Plans of reorganization, that I'm going to just touch on this briefly. Plans of reorganization that have been achieved so far have all been by consent, by agreement of the parties. There is a process in a bankruptcy case, and perhaps Archbishop Hebda will talk about this later, because it nearly came to that in the Minneapolis St. Paul case with which he's familiar. There's a process to cram down a plan, confirm a plan by what we call cram down, even though all the creditors and parties in interest don't consent. But we haven't seen that happen in any of the Catholic organizational cases so far. Well, I know I've left a lot of questions unanswered, and there's a lot more to talk about, but I'm going to wind up my remarks to make sure that we have time for our other speakers. And again, want to welcome everybody to contact me outside of this meeting, or later on in our question and answer session, and I'll try to answer what's on your mind.
Thank you, Marie. I appreciate very interesting presentation and very helpful and informative. For the question period, we should mention that at the bottom of your screen there is a chat feature which allows you to click on that, and then that would and you can ask your question there. When we get to the questions, you're free to put that in at any point along the way, so that we can find the questions when it comes time to get to the question and answer. Marie has given us the idea and concept of bankruptcy and what it means, and now we'll look at a particular instance and how this all gets applied. And we're going to start with Brian Wenger, who is a lawyer and is the former chair of the law firm of Briggs & Morgan, a leading law firm in Minnesota. He was the chair of the Archdiocesan Finance Council in St. Paul and Minneapolis, and and after that became the lead outside counsel for the Archdiocese in its preparation for the bankruptcy. So he has particular insight into the way in which all of that took place, both from a professional and from an experiential point of view. So, Brian, to you.
Thank you, Bishop, and good afternoon to everybody, and good morning to maybe a few of you. I'd like to talk about 4 areas that I think would be helpful. Number 1 is, what are potential goals that one might consider in deciding whether to use the bankruptcy process that Marie just went through? Second is, who are the types of personnel and decision-making processes that might benefit you in deciding whether to take advantage of the bankruptcy process to reach the potential goals you have? So personnel and decision-making, number 2. Number 3 is preparing for that decision and the types of facts and evidence that you probably would want to gather to decide whether to go into bankruptcy. And then number 4, might there be a new way? And as you can see, I'm not touching on how it is to live in bankruptcy, which Marie talked about, and I know Archbishop Hebda will spend some time talking about. I just wanted you to know I'm leaving that topic for others and for a Q&A. Okay, if that sounds good to you, I'm going to turn to the first topic, which is potential goals. Many dioceses have articulated why they went into bankruptcy and what they thought were important goals to try to achieve. I just want to list some of them. One is the fairness of restitution. Marie touched on the fact that, and John touched on the fact that there's the first to the courthouse shouldn't necessarily get the whole pot. There should be a spreading of the benefits or of the remuneration to those who are harmed or have been harmed by the church. So is that a goal? The idea of restitution, something that's spread amongst all of the potential claimants, number 1. Number 2, healing. Healing for the victims, healing for the diocese, healing for the priests in the diocese, healing for your staff. How does that feature of healing best get served, whether inside or outside the bankruptcy? Number 3 is carrying on the mission of the church. The reality is that your diocese and the Catholic organizations in your diocese have an incredible influence on the broader good and the care for those most vulnerable in your diocese. A simple fact that might drive that home with regard to the Diocese of Philadelphia. The total revenue and expenditures of Catholic and Catholic-related entities in the Diocese of Philadelphia in the year, I think, 2018, is equal to the total general fund of the whole city of Philadelphia. You know, so those organizations, when you add Catholic hospitals and Catholic universities and Catholic dioceses and Catholic community foundations, et cetera, the effect on the community is significant. And so how does one make sure that the carrying out of the mission of the church happen? And how does bankruptcy affect that? Goal number 3. Goal number 4, is transparency an important part of the healing process and a goal that you wish to espouse? As Marie mentioned, there's more transparency in bankruptcy than otherwise. Next is finality, bringing all these matters to a close, which can have benefits for both the victims and for the diocese, and speed to resolution. Without bankruptcy, you will have continually have a suit after suit after suit filed. So the whole issue will journey on for many years and will be in the press for, claim number 14 and claim number 27. And there's a long journey there. So is our speed and finality a factor to consider? How much do you want to take a view of victims first? That the sort of prioritization of harm and how to take care of where did the import of the victims fall in your decision-making process. So these are goals that have been articulated and evidenced in decision-making in other dioceses which have gone into bankruptcy. I'm confident I haven't covered them all, but just to give you a sense of things to maybe think about in deciding whether bankruptcy is appropriate or not. Those are potential goals. So how do you think about and go through the decision-making tree? Well, I would say in the simplest of terms, you need to have the right people around you and the right decision-making process, those two areas. So who are the right people? Well, obviously it's who you decide, but do you want a quarterback, so to speak, that sort of is day-to-day point on these throughout the process? And who might have the range of skills to be the quarterback? Someone with financial acumen, somebody with empathy, somebody with experience with the court systems, potentially somebody with bankruptcy experience, potentially somebody that's well known in the diocese, potentially somebody that's engaged with Catholic entities throughout your diocese. You know, you have to decide whether you want a quarterback. Is that a priest or not a priest? Questions for you to decide. Two is Marie laid out what I'm sure was some multitude of foreign words, estate as a bankruptcy concept. Who are the lawyers that you're going to rely on? And the lawyers who have been your lawyers in the past, are they the lawyers that are right for deciding the go forward process? Those lawyers may have been advocating a course of action that's completely different than a bankruptcy course of action. Can they pivot? The bankruptcy lawyers you're going to face who represent all the claimants are seasoned, nationally known, active, and experienced. Do you have the right team to go against them in your diocese? Or do you need to augment that or substitute that with others? Just a question to work through. There will be a multitude of sources of information coming forward. Who is the source and where are the sources of information for communication by you? Who's your spokesperson? Are you your spokesperson? If your spokesperson is other than you, is it clergy? Is it not clergy? Who would be the appropriate person to speak to the press, to speak to those victims, to speak to Catholics who are concerned, to speak to the priests, to speak to government officials? Who is your team for communicating? And then there are third-party consultants that you'll for sure want to think about bringing in to help you with decisions, reviewing what your asset bases are. What assets do you have? And we'll go into that in a minute. What's insurance? Do you have insurance? Do you know if you have insurance? Can you find all the insurance you have? Because all these claims are from 30, 40 years ago. So an insurance archaeologist is someone that you might bring in, but bringing in the right group of third-party consultants. And then there's the decision-making process. So how frequently are you going to have meetings? Who's in the meetings? And what's the decision-making process in those meetings? Your calendar that existed in that pre-petition era that Marie talked about is going to be rewritten in the post-petition period, because there's just going to be demands of time and decisions that have to be made, and they're governed by courts where you don't have the luxury of delaying it. And you'll just have to be blocking out some significant time. And how do you have an efficient decision-making process where information can be gathered and brought to whomever you trust? So thinking about an organizational structure for having the team. And then the reality is, with regard to that team won't stay intact through the bankruptcy process if you go into bankruptcy. People will opt out because the stress and burden of it will be too great. You'll find that you need to supplement or replace members on that team. So it'll be a dynamic team that will be working with you throughout the bankruptcy process if you go into it. But certainly you can define the team that helps you make the decision about whether to go into bankruptcy. So there's a heavy burden on your staff and on those that are on this core team when you're making the decisions along the way. It'll be a heavy burden on you too, physically, mentally, emotionally. It'll be a very tough period, and just having the ability to sort of run the course, run the marathon is important. So I've talked about potential goals, having the right decision-making process, the right personnel, whoever you deem appropriate to help you. And then how do you go through the decision-making process now that you've got everybody, so to speak, in the room and ready to go? Here's some things to consider. And I think that one thing Marie could say from her analysis of the 12 bankruptcies so far, wherever we're at, is none of them are the same. It's a puzzle. And so putting the pieces of the puzzle together for what's best for your diocese will mean it will not be the same as other dioceses. So here's some concrete examples. Reviewing the claims that you have and the extent of public disclosure that's happened so far on those claims. In all honesty, some dioceses have only had a few claims. Some have had a mountain of claims. Some are well known, some aren't known at all. Some have been resolved quietly and they'll become more known through a bankruptcy process. Some are very public. So understanding just what's the claims environment is a task. It's a big task. We actually had just a sheet of paper that was about 10 feet by 12 feet that laid out a multitude of information on some spreadsheets. They had to have it specially printed just to digest the magnitude of where we were on what we thought were all key elements on these various claims. Second is understanding the financial resources. When Marie talks about the estate, those are the assets that you have. The reality is you can't just look at your balance sheet and say, aha, I now know how many assets we have. Because on your balance sheet will be simple things like cash, investments, real estate. But when you get to real estate, it won't be valued at fair market value. What's the value of your cathedral? It'll be valued at a book value or a depreciated value. And so it doesn't really reflect the exact value. You'll have insurance. You might have assets which are quote unquote called off balance sheet, like insurance funds for health insurance for your employees or pension funds for retirement for your employees or for the school teachers in your Catholic schools or whatever. Those are assets that there'll be a question, should they be in the estate that's available for the individual victims? And they might not be sitting on your balance sheet. So first of all, figuring out what all the assets are that might be available for the estate. And then of course is insurance. How much contractual right to insurance do you have? And how much of it do you think you can get access to sort of build a bucket of funds that are available to take care of these claims? Every diocese has handled their insurance matters differently. And it'll be a big effort to figure that out. So number one, very simply, is reviewing the claims. Number two is figuring out what assets you have. Number three is figuring out the climate. So if you would with me, think about the legislative climate in your state. It can be very different in every state. Do they want to open up the statute of limitations so that more claims can come in over a longer period of time? Do they not? Do they? Does the city in which you're located have a governmental structure that's more attuned to speaking out or maybe speaking against the diocese? The police department, are they going to want to issue a warrant to obtain documents? Is the public defender's office going to come in? Thinking about all the governmental entities and where might they play if there is a bankruptcy is an important factor to understand. Next, understanding the relationship that your diocese has with entities that are Catholic. So, are you corporate sole or are you not? Do you have contractual relationships? As an example, do you own the high schools? Do you own the land under the high schools? Do you own the grade schools? Does the parish own the grade schools? Is there debt on any of those where banks have a first right to some of those assets because you borrowed against that to build the high school? You own the land and you borrowed to build the high school, as an example. So what are those contractual relationships that define some of these assets that might be available? And then governance relationships. Do you exhibit control over these entities or not? And whatever the degree of control you are exercising or not exercising, is it consistent with what your intended exercise is or is not? And is it consistent with what the governing documents say the control is or not? And understanding that whole picture helps define, are some of those assets that you may not think are part of the diocese may become part of the estate, or it might actually pivot the other way, where there are some assets that you think are diocese that you find out are not. There might be some trust documents where a wealthy individual donated money for a specific purpose in your diocese. Well, is that going to be respected or not? What do the words in that trust say? That trust might be 20 years old, and they might not have worded it as well as, you know, one would have wanted as we are today. So understanding the legal relationship, whether it be governance or contractual or other, is an important step with regard to being prepared. And then the final couple things are discussions with others. It's probably true that if you're actually at the point where you're thinking about bankruptcy, that others are thinking about the fact that you might file for bankruptcy. So there may be a Catholic community foundation in your organization which is curious about it. There may be a Catholic schools group that's interested in it. There may be groups doing capital campaigns and wanting to make sure that the money that they're raising for capital purpose is actually going to be respected and not used for the bankruptcy process. There will be natural discussions with regard to others who are in the Catholic realm in your diocese, and just spend a little time thinking about those discussions and what's appropriate and what's not appropriate as you prepare, so that you understand how your decisions might affect those organizations, whether intentionally or unintentionally. Final point on this issue is there is the possible for criminal involvement here. Marie talks about the fact that bankruptcy is a civil process. It's controlled by federal law and there's state law. That's all true. There also is the possibility that there may be an assertion that there was criminal conduct by the diocese or by priests within the diocese. And to make sure that you have appropriate counsel about that possibility, I'm not suggesting it in any way would be appropriate, but that's a possibility, and that's layers in a whole nother dynamic as to what the exposure may be for the diocese beyond the economics handled in a bankruptcy. The fourth topic that I wanted to share with you is simply, is there a new way or a better way? Just because there have been 20 bankruptcies in the past and that they've all been consensual doesn't mean that's the way matters in your diocese need to be handled. There could be the quote unquote cram down that Marie talked about. There could be a legislative solution. If you would think about this for a moment, in any bankruptcy process, the following are always true. You have fees that you have to pay. You pay, or the estate pays, which is your money, pays the fees for your lawyers and your advisors. The estate pays the fees, in essence, for all the plaintiffs' lawyers and all the committee's lawyers. And it pays all the expenses. So there's a substantial amount of money. It'll be a third or more of the total money that goes out goes to lawyers. And so is there an opportunity through a legislative solution or a collaborative contractual solution, probably the only one that can work, just so you know, is legislative, to reach some sort of a resolution that's different, where those funds can actually be used for the purposes of continuing the work of the Archdiocese or taking care of the victims. I'm just saying, allow yourself to be open if someone suggests an alternative method for resolving all the claims. It isn't cookie cutter, and there are opportunities for something different. Thank you. I hope that was helpful, and happy to answer questions during the chat or thereafter.